Court is calling 2022 CR 10641, State of Texas versus Wayne Tolliver. Could I have parties announced for the record for the state?
David Cruz on behalf of the state, Your Honor.
Defense?
Patrick Valentine on behalf of Mr. Tolliver.
Are you Mr. Tolliver?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
We have your
Court will find that the state is in compliance with discovery. Mr. Tolliver, I'm showing you what's entitled True Bill of Indictment. Did you review this with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, we're waiving the repeat enhancement allegation, Your Honor.
No objection.
All right. All right. I don't know why this, somebody explain to me why on the trial rights to appeal somebody checked.
Oh, I'm sorry, Judge. Some courts prefer it. I didn't mean to step into your prerogative.
All right. So you're proceeding on the indictment as presented?
We are, Your Honor, with the exception that we'd be waiving the repeater allegation.
Any objection?
No objection.
Mr. Tolliver, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with driving while intoxicated, third or more?
Yes, Your Honor.
The range of punishment for that offense is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
No, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
You understand?
Okay.
Yes.
You understand your rights in this case?
Yes, Your Honor.
All right. Do you understand by entering this plea bargain agreement, you're giving up those rights?
Oh, yes, Your Honor.
Do you want to give up those rights and enter into a plea?
Yes, Your Honor.
All right. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
You believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Tolliver, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishments be assessed at a cap of 6 years in the prison and there are no applications.
Pause right there when the state says they're waiving the repeat enhancement allegation. That's huge. In Texas, enhancements can dramatically increase prison exposure. Dropping that repeater can mean the difference between a manageable sentence and something much harsher. Strategic move by the prosecution, but why weak proof on prior's negotiation leverage? Let me know what you think.
Do you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State, any evidence?
Your Honor, at this time, the state introduces state's exhibit number 1 and all of its attachments.
No objection.
All right, state, you can continue to confer. Showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. State, I'm sorry, not state, probation.
Yes, sir.
On this case, I'm going to need a PSI, TAP evaluation, and referral to felony drug court. Is there anything else from either side?
No, Your Honor.
All right, we're going to come back on May 4th at 9 a.m. And at that time, the court will make a decision on your punishment based upon the PSI report and any other information I receive.
Yes.
All right, thank you.
Thank you.
All right, the court is calling 2021 CR 11632, State of Texas versus Efron Martinez Soto. Could I have parties announced for the record for the state?
Debbie Cruz on behalf of the state, Your Honor.
Defense?
A little for defendant.
All right, and are you Mr. Soto?
Yes, Your Honor.
All right, and according to the plea bargain agreement, the restitution is for $2,000. Is that correct?
That's correct, Your Honor.
All right, the court will follow your agreement, sentence you to 3 years deferred adjudication. There's a $1,000 fine to be probated. A restitution of $2,000 to Catherine Muras, M-U-R-A-S, is to be paid today,
Yes, Your Honor.
March 23rd. There's to be no contact with Catherine Muras. 150 hours community service restitution. Do you have any children?
Yes.
What are their ages?
From 13 and 7.
Do they live with you?
Yes.
All right. There's going to be 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to have that, but if you do, 40 hours will be waived. I'm going to ask for parenting classes. Once that's completed, the remaining of your community service hours will be waived. There's to be the anti-theft course, regular reporting to probation by Zoom or in person, regular UAs. I'm going to want field visits one time per month for 3 months. Probation, if you want to count his field visits as reporting, you can. If there are no issues after 3 months probation, you can resume field visits as you deem appropriate. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs?
Good.
Thank you. Yes.
One other matter. I was conferring with
This is the judge doing what's called admonishments. It might sound routine, but this is constitutional level protection. The court is making sure Mr. Tour understands he's facing 2 to 10 years for a third DWI. That's felony territory. Once you plead, you're giving up your right to trial, confrontation, silence, all of it. Quick questionando. You think most defendants truly grasp what they're giving up in moments like this?
Jason Garahan about this particular case and indicated he didn't have any objection if I asked, given that he paid all the restitution up front, a shorter term of the deferred adjudication, given the restitution was all paid up
Well,
front.
I mean, once he completes everything, if he completes everything, the court will consider early termination.
Thank you. Second thing, Your Honor, I want the court to understand how he found himself in this situation. He's a contractor. He had been doing some work for this young lady's father.
Mhm.
She had hired him to do some roofing work. He subcontracted some other roofers and they disappeared with the money. He had been communicating with the father, had already paid up about $1,800. When the case was brought, it was a balance of $2,000. So that's how he found himself in this situation.
Okay.
He's implementing some new business practices.
Oh, yes. You know, people just want to jump in and start a business, but you got to know who you're hiring and stay on top of everything.
Well, and the crazy thing is, he said he's used this roofer in the past, like for 5 years.
5 years.
Oh.
And he disappeared with the money.
All
That's
right.
how he found himself in this
Okay, you want to go around?
Yes, Your Honor.
Nobody, everybody thinks that they're stretched from the,
Actually, I think I could have pulled it off.
you think you could have? Okay, we're going to try that. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. What is happening on this case?
Judge,
You can the other side.
I've conferred with the state. There's still some discovery that I need to obtain from them.
All right, what discovery is it? Because the court has that on January 26th, a discovery acknowledgement was signed and filed. So what discovery is outstanding?
There's the child safe interview. And I understand the state now has copies of the polygraph that was given to the defendant.
All right, state, do you have that?
We do, Your Honor. He just needs to make an appointment to view the child safe.
All right, and then the polygraph?
The polygraph, we can prepare copies for him. They're in the file.
All right, can you give that to him today since he's here?
Yes.
All right.
I'll get that.
All right, anything else?
No, Your Honor.
Has an offer been tendered?
An offer was tendered today.
All right, Ms. Ferguson, I need a 3-week reset. You can put this in April. It'll be for a plea deadline date.
April 6th.
All right, April 6th will be your plea deadline date. You'll need to let the court know whether or not you're accepting the state's offer. After that date, the court will not accept any plea bargain agreements with not good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, Your Honor.
All right.
Yes, Your Honor.
And then has he already received the immigration information?
Yes.
Okay. So that's completed.
Yes.
All right. Thank you.
Thank you, Judge. May we be excused?
Yes. All right. So what is happening with this case?
Judge, you had reset us. The state was looking for 2 items. One, surveillance footage from a restaurant across from my client's house that may have had footage, and apparently they checked, and the surveillance footage they checked doesn't show anything. Just the cameras weren't pointing at anything. But they, Jason said he emailed the detective about some reports about prior incidents between the complainant's family and my family, but he hasn't responded. The detective hasn't responded yet.
So when?
I can follow up again, Judge, with the detective, but he hasn't replied to me from a couple weeks ago.
All right. So on February 6th, we were here for discovery. Video, if it exists, which I'm being told it does not exist. And then prior reports between the parties. And so we're still waiting on prior reports between the parties?
Yes, that's part. He hasn't. I don't know. I know he has some way to check for past incidents from particular address.
Erase the key. The cap is 6 years. The statutory max was 10, so the defense carved 4 years off the top. That's real negotiating, but remember, this isn't a promise of 6 years. It's a ceiling. The judge still decides within that cap after reviewing the PSI. Would you roll the dice at trial or take the certainty of a cap?
But he hasn't, as far as I know.
And Judge, we know they exist because the complainant's sister had a no contact order. She was not supposed to trespass or contact my client's family based on some prior incidents, but I don't have any offense reports, and that's what we're trying to find out, whether or not the brother was mentioned as well, the decedent.
And I'm sure you do not wish to proceed without having that documentation. Correct. All right, Ms. Ferguson, I'm going to give you all 3 weeks. And if you don't hear from that officer, then he needs to be subpoenaed for a hearing to find out where the reports are and if they exist and why Mr. Maurer doesn't have those. All right, what date? All right, so we're going to come back on March 30th.
And Judge, I conferred with the state about the GPS, and we can't come to an agreement about removal. So I'd like to see if you can refer me to either Judge Carruthers or Judge Nahara for a hearing.
Okay. All right, we'll refer you to Judge Nahara. For some reason, they have moved Judge Carruthers' court. Nobody was informed. They just told him, I think, on Friday, you're moving on Monday.
Like from where he's always been, he's not there anymore.
No. So somebody who knows have decided to give him a courtroom, that there is no space for a court reporter. So the court reporter won't have an office. There's really no space for clerks. Again, I always tell people before you make decisions, like walk the building.
Well, the Impact County Court offices don't have telephones, so that tells you about how Garrett County works.
All right, so we'll come back on March 30th.
All right, thank you, Judge.
And then Ms. Ferguson will give you a reset form. And then if Judge Nahara can't hear it, then I can hear it.
Okay, I'll go check with them.
Thank you. Jacob Guevara, we're still waiting for her to come back on that.
He's up here, Your Honor.
Jacob Guevara, if you could come down, please. Court is calling 2022, and counsel, you over here. Court is calling 2022 CR 7321, State of Texas versus Francisco Carlos Aguilar. I have parties announced for the record for the state.
We have the state, Your Honor.
Defense.
Hector Garza Jr.
And are you Mr. Aguilar?
Yes, Your Honor.
All right. You entered a plea of no contest in January. This was set for today for a PSI. According to the plea bargaining agreement, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor.
And just like that, appeal rights mostly gone in plea bargain cases, especially in Texas. If the judge follows the deal, your ability to appeal is extremely limited. That's finality, that's leverage, that's the system prioritizing efficiency, fair trade-off, or too much pressure on defendants. Sound off below.
No, Your Honor.
I have, Judge.
All right. Defense, do you have any objections to the PSI report?
You know what, Judge? I don't have objections, I guess, to how they carried it out, but I do take a huge opposition to the suggestions that are made from probation. I rarely question too much of what they do, but they got this one way wrong if I'm reading this correctly.
All right. Are you employed?
Yes, ma'am.
What do you do?
I'm an insulation contractor and I have my own business.
Okay. All right. The court will follow your agreement. The court is going to sentence you to $250. That will be probated. The court is going to sentence you to 1 year's deferred adjudication, 60 hours of community service restitution. Do you have any children?
Yes, ma'am.
What are their ages?
My youngest is 10, 16, 17, and my oldest is 24.
All right. I'm going to ask for parenting classes. Once you complete the parenting classes, the community service hours will be deemed to be completed.
Yes, ma'am.
There's to be no contact with Lev, L-E-V, O'Kelly, O-K-E-L-L-E-Y, anger management course, proof of employment within 15 days, no employment as a home health care provider or with minors, regular UAs, regular reporting by Zoom or in person. Probation, I'm going to want one field visit. If everything looks...
Notice something important: there's no dramatic witness testimony, no cross-examination fireworks. This is what most felony cases actually look like: paperwork, stipulation, sufficiency. The PSI pre-sentence investigation now becomes the battleground. That report can shape everything from prison time to probation. Sentencing is where the real fight shifts.
It's okay with the field visit, then you don't need to do any more field visits. And if you want to count that first field visit as his first reporting, you can. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful?
I submitted my proof of employment to
Probation.
yes, ma'am, during my interview.
All right. Well, just let them know. Okay. Do you need anything else from the court?
Your Honor, if I may, Judge, I do have one request potentially. Judge, this situation, the case itself was a fight between the victim and a third party, another cousin, if you will. Frank stepped out to stop the altercation and was accused of hitting the victim. Against my recommendation of taking this case to trial because family members would have had to been brought in, Frank decided to move forward with the plea bargain because he just wanted this done and not involve family violence. I've actually known Frank since I started my legal career 18 years ago. The first office that I officed at was directly behind a Wendy's restaurant that Frank was managing in 2005, and I've known him since.
So what are you asking for, counsel?
The anger management class, Judge, I believe in this case is excessive. I would ask potentially that the court hold it in abeyance. If another situation arises, then by all means have him complete it. But I really feel that that is not going to happen here. And I just feel that it's overkill given the situation and the true facts of the case.
All right. The court is keeping in place the anger management. Is there anything else?
That was the only thing.
All right. Thank you.
Thank you. Thank you.
Thank you.
This right here is a quiet win for the defense. Dropping to a lesser included offense from something potentially more serious down to a Class A misdemeanor can protect someone's future in a big way. Deferred adjudication means if he successfully completes probation there's no final conviction entered that's life-changing in terms of employment and background checks. The real question now, can he stay clean and complete every condition without slipping up?